Come to order, and I was just saying to Senator Tillis, sorry we're starting a little bit late, but we had a vote right at 12:30, and as far as we have to vote in person, took a bit, but he's younger, he got here quicker. I'd note that patents are a powerful tool for innovation. In exchange for disclosing how an invention works, a public grants an inventor a limited monopoly to produce and sell an innovative product, which is a great part of our legal system. If you're protecting a genuine innovation, that can attract the funding necessary to build a business, provide legitimacy to somebody who might be a non-traditional inventor, to help create American jobs. Good quality patents provide more certainty to small businesses and inventors so they can defend their invention from infringers. And given the power that a patent conveys, ensuring that the U.S. Patent and Trademark Office issues the highest quality patents possible is, of course, what our founders intended when they wrote the Constitution. But there's another side to the patent quality coin, one that can result in serious consequences for our economy and society at large if the system produces patents that never should have been issued in the first place. Vermonters faced these consequences firsthand when an out-of-state company asserted poor quality patents against dozens of Vermont small businesses and nonprofits. Now, we're a small and close-knit state, but Vermont mobilized in force against the company. They realized what was happening, and they came together. This company, which held patents covering the common activity of scanning a document and emailing it, something that every one of us has done at some time or another. So testifying about Vermont's experience will be Bridget Asay. I've had the pleasure of speaking with her earlier this year. She's going to be with us remotely. She led the Vermont Attorney General's lawsuit against the company abusing these patents and did a superb job. But Vermont's experience is just one case study of what can happen when poor quality patents infect the system. We're going to hear other examples today, including the disturbing story of how the disgraced Silicon Valley company Theranos and his founder, Elizabeth Holmes, obtained hundreds of patents for an invention we now know was fraudulent. But it becomes even worse than that. Not only do those patents for an imaginary invention still exist, but some were issued even after the public knew about the fraud. What's more, they've been asserted against actual inventors and innovators who are working on steps that can be taken to curb COVID-19. So think about it for a moment. Here we have the whole world, not just the United States, but we're scrambling to respond to a devastating global pandemic, millions of lives at stake, genuine medical technology designed to help us understand the virus spread was nearly blocked by patents for a fake invention. Actually, I wonder if it wasn't for the bad publicity that came out, these patents might have successfully thwarted real innovators, cost actual lives. So we should all be outraged by this, but we also should make sure the law is such it can't happen. We think about patent quality, we should also keep in mind that 52%, more than half of U.S. patents, are issued to foreign entities, even more likely transferred to foreign entities after they're issued. But we don't know how many patents are ultimately owned by foreign entities because PTO does not require the patent owner to tell the public, who might be on the hook for infringement later on, that the patent was sold. So there's a real risk that foreign companies build portfolios of poor quality patents, then weaponize them and use them not to help their country, but to stifle American innovators. So we have to improve patent quality. And getting patent quality right has real stakes. I'm proud of the work we did 10 years ago in the Leahy-Smith America Invents Act, addressing patent quality after patents have been issued. The post-grant procedures we put in place helped invalidate some of the patents that were asserted against Vermonters last year. I respect the Supreme Court's decision yesterday in the Arthrex case, which touched on these proceedings. I am confident the PTO, the Patent Trial and Appeal Board, will contribute to be able to perform the duties the Congress gave them under the Leahy-Smith Act. But the focus of our hearing today is on improving patent quality at the outset before patents issue. Preventing poor quality patents from ever issuing is just as important as eliminating bad patents later. In fact, in many ways, it's more important. Now, I know that Senator Tillis shares my concern about patent quality. He has expressed himself eloquently on this. So I hope I can work with him. This should not be a partisan issue. I hope we can work together and find ways to protect. And I yield to Senator Tillis.
Thank you, Chairman Leahy. I want to thank you for holding today's hearing, and I really do appreciate your long-term commitment to ensuring patent quality. There's clearly a reason why the biggest patent quality reform in more than 60 years bears your name. A strong patent system promotes...
Incidentally, if I could interject, I did not name it after myself. It was the Republican chairman in the House who named it to me. I was just... It is one of the most happy moments I've had because he did it.
Well, that just proves that on issues of intellectual property, we can come together on a bipartisan basis. A strong patent system that promotes and protects American inventions is critical to our economic success, our job creation, and global competitiveness. But a strong patent system isn't judged by how many patents we issue. It's instead judged by the quality of those patents and their ultimate strength. If we think of each patent issued by the USPTO as a brick upon which we're building our innovation infrastructure, then our job, and that of the USPTO, is to ensure that those bricks are strong. Good quality patents must stand the test of time, the scrutiny of the courts, and used as intended to support and not limit innovation. This type of quality control is ongoing, and it's an iterative process. Patent quality isn't an issue that's stuck in time or is fixed and then never readdressed. In 2019, when I was chairman of the subcommittee, along with my colleague, Senator Coons, who was then ranking member, we held a hearing to address how Congress can help prevent the issuance of poor quality patents. Since then, the USPTO has made many improvements to address patent quality concerns, including improvements to its quality control process, prior art searches, and how patents are assigned to examiners. Yeah, there's always room for further improvement and innovation, whether by enhancing technology used for prior art searches, increasing collaboration domestically and internationally, or helping to ensure clarity in written descriptions. One way Congress can assist in these efforts, for example, is to eliminate fee diversion. This would allow the USPTO to devote resources to hiring more examiners, improving training, and making sure that patents are of the highest quality. Congress should also look at ways to improve the USPTO's examination procedures as it relates to scope, written description, and enablement. There are simply too many overbroad patents being issued, especially in the software and financial services spaces. And if we could simply reduce that overbreadth, we could solve a lot of problems. Finally, I think Congress should consider creating a gold-plated patent. In my mind, such a patent would undergo a more rigorous, more costly examination process to make sure it is truly new, innovative, and properly scoped. But in return for doing so, we would guarantee that the gold-plated patent holder, that their innovation would be virtually impossible to challenge. I'm curious to hear from the witnesses on your thoughts about creating such a patent. I'm also interested in hearing from today's witnesses about their own ideas, no matter how big or small, to improve patent quality in our intellectual property system. And with that, I want to thank you all for being here today. I look forward to your opening comments and your testimony. Thank you, Mr. Chair.
Well, thank you, Senator. And here's the witnesses. We'll have Bridget Asay. She is a Vermont attorney. She's practicing with Stris and Meyer. She's a member of the American Academy of Appellate Lawyers. Before she joined the law firm she's with now in 2017, she worked in the Vermont Attorney General's office for 18 years. She actually became Vermont's first Solicitor General and did a tremendous job as such. She graduated from Harvard University and Yale Law School. I will have Julio Garceran, Chief Intellectual Property Counsel at Cree Inc., a semiconductor manufacturer located or headquartered in Durham, North Carolina. Nothing parochial in this hearing. The two lead witnesses. But he's also participated and managed all aspects of patent practice, previously a corporate counsel at a large multinational telecommunication company, is a litigator, patent prosecutor, intellectual property law firm, graduated from the University of Miami, the Florida State University College of Law. Troy Lester is vice president, patents for a Cushnet company, a golf industry leader, manufacturer of Tillis, I always mispronounce that, another famous brand. He's been responsible for their patent portfolio for over 20 years. Participates in the Patent Policy Working Group of the Global Innovation Policy Center, the U.S. Chamber of Commerce, and received his JD and BS in Mechanical Engineering from Arizona State University. George Contreras, a professor of law at the University of Utah, S.J. Quinney College of Law, serves as a senior policy fellow at the Program on Information Justice and Intellectual Property at American University College of Law, honors graduate of Rice University and Harvard Law School. And we will, what order are we going to test first? Asay. Then Ms. Asay could testify first, and she'll be on one of these big computer screens, which I have nothing to do with. People who actually know what they're doing are going to put her on.
Thank you. Senator, should I begin?
We hear you, we don't see you yet. There you are. Hi, good to see you. You're making
Thank you,
me
Senator
jealous.
Leahy.
You're probably in Vermont.
I am in Montpelier, Vermont today.
I'm jealous. Go ahead.
Thank you all, the members of the committee and Senator Leahy. My name is Bridget Asay. I'm an attorney practicing with Stris and Maher, and before joining the firm, I spent 18 years working for the Vermont Attorney General's office, where I served as Vermont's first Solicitor General. Thank you for the opportunity to testify today about a concrete example of the problems associated with low-quality patents. In 2013, when I was working for then Vermont Attorney General Bill Sorrell, our office received complaints from a number of small businesses, including 2 nonprofit agencies, that have received letters accusing them of patent infringement and referencing imminent litigation. One of these organizations operated on state and federal funding to bring home care to developmentally disabled Vermonters. Another provided fiscal agent services to Vermonters with disabilities to assist them with daily living tasks. We later learned that about 75 Vermont businesses and nonprofits received these letters. The letters were sent under the names of a veritable alphabet soup of 40 different entities with names like BARMAS LLC and HARNOL LLC. Regardless of name, the content was basically the same. What I'll call the first letter listed 4 patents and a pending application and said that the targeted businesses likely had infringing systems. What were these patents and infringement claims about? The letter described as the basis for infringement a typical office network with a server, computers running Outlook, and a scanner that permitted scanning a document directly to an employee email address as a PDF attachment. Pretty common office equipment. The letter said that the fair price for a license was $1,000 per employee, meaning easily $10,000 or more, even for a relatively small business. Follow-up letters came from a law firm. A number of the targeted businesses received a letter that included a copy of a legal complaint and said that the company would sue if they did not receive a response within 2 weeks. This didn't just happen in Vermont. These letters were sent to small businesses across the country. The FTC conducted an investigation involving MPHJ Technology Investments, LLC, the owner of the patents, and the documents from the FTC matter can be viewed on their website. The FTC alleged that over 16,000 small businesses nationwide were contacted. Back in Vermont, these businesses weren't targeted because of any products they manufactured or sold. These were not software or tech companies, they didn't make scanners, and they weren't experienced in patent law. Receiving a letter like this puts a small business in a very difficult position. They don't know if the litigation threat is real. The amount of money is significant, but probably a lot less than they'd have to pay to defend a lawsuit. Patent law is specialized, so lawyers that handle their routine matters are not necessarily going to give advice on patent infringement. Patent lawyers are expensive, and consulting with one might cost as much as paying for the license. The Vermont Attorney General's office filed a consumer protection lawsuit against MPHJ. That case alleged straightforward consumer protection claims. We did not contest the validity of MPHJ's patents because that's a matter of federal law. But I think the history of our state litigation is relevant because it highlights the point I made earlier that most businesses can't take on the risk of litigation in this area. That case was filed in state court, removed to federal court, remanded to state court, appealed to the federal circuit, which upheld the remand, removed a second time to federal court, remanded a second time, and appealed a second time to the federal circuit, all in all lasting 4 years before it was settled. It took substantial resources to pursue that litigation. It was a lot for our office, which is small by national standards. A small business could not sustain that kind of litigation. The costs would be ruinous. As I mentioned, our litigation did not contest the patents because that's not a consumer protection matter. But there were proceedings brought by large scanner corporations, and I provided citations to some of these proceedings in my written testimony. I'll just cite one example. The first letter that I referenced before referenced a pending patent application. That patent issued in 2013, and 4 years later in 2017, the federal circuit upheld a decision invalidating the claims in that patent. So that one proceeding took 4 years. There were several other proceedings, and again, it took cases like HP, Xerox, and Ricoh to pursue those cases. A small nonprofit serving disabled Vermonters could never do that. As Vermont's example shows, there are real costs when low quality patents are issued. I hope the committee will consider concrete actions to improve patent quality. Thank you for the opportunity to testify today.
Thank you very much, Ms. Asay, and it's good to have you with us. And now, Mr. Garceran, from Durham, North Carolina.
Hello. Good afternoon. I would like to thank Chairman Leahy, Ranking Member Tillis, and distinguished members of the Subcommittee on Intellectual Property for the opportunity to present my views today on patent quality. My name is Julio Garceran. I'm the Chief Intellectual Property Counsel for Cree Incorporated. Cree is a compound semiconductor company based in Durham, North Carolina. Cree was founded in 1987 as a startup out of North Carolina State University and backed by North Carolina State University patents. Cree is an American success story, and patents were critical to that success. Throughout its history, Cree has been at the forefront of silicon carbide and gallium nitride materials and devices. Cree started the LED lighting revolution and is now leading the transition from traditional silicon to more energy efficient and robust silicon carbide. Unlike some influential companies that rely on other mechanisms to protect their technology, Cree relies heavily on patents. Once Cree's products are sold in the marketplace, would-be competitors can obtain those products, reverse engineer them, and indiscriminately copy those products. Cree's patent portfolio is essential for preventing such behavior. Therefore, Cree, like domestic manufacturers and innovators, needs a strong patent system. So why are we here talking about improving patent quality? Low-quality patents hurt business. The high cost of patent litigation fuels a business model where patent trolls bring patent litigation not to legitimately enforce a patent's technological scope, but to squeeze legal settlements from companies. The high cost of patent litigation can also create an incentive for low-quality patent owners to file patent litigation against smaller competitors, not to recoup compensation for the use of patented technology, but to burden the competitor with increased spending. These costs are better spent on more productive endeavors like research and development, and can be very detrimental to a small business. With increased patent quality, companies can at least make a rational business decision based on the technological merit of the patent. Increasing patent quality would hopefully lead judges to more confidently and consistently entertain making early case dispositive rulings. Low-quality patents also create an uncertain business environment. Patent quality adds certainty surrounding the validity and legitimate technological scope of the patent. An inventor or venture capitalist can be more confident in investing money in a new venture that owns or licenses high-quality patents. When the Cree founders were trying to raise money, Cree's licenses to the North Carolina State University patents were critical. In my view, there are various practical steps that can be taken to increase patent quality. First, keep USPTO revenues in the USPTO. Diverted USPTO revenues could fund improvements to the examining force and the infrastructure of the USPTO. Increase the use of 35 U.S.C. Section 112 in examining patents. The outcome of a patent litigation typically hinges on the meaning of a single or a handful of claim terms. In some instances, the meaning of the claim term is ambiguous. In other instances, the meaning of the claim term is relatively clear, but the low-quality patent specification does not support a broad meaning for the claim term. Section 112 is supposed to ensure that claim terms are clearly defined, reflect the invention that was actually possessed by the inventor, and are enabled by the patent specification. However, Section 112 rejections are generally considered non-substantive and are not pushed at all during patent prosecution. Finally, adjust examiner incentives. Examiner incentives need to be adjusted to make quality a priority. The current count-based system appears to encourage quantity over quality. In conclusion, efforts to improve patent quality should not weaken the patent system or result in overly narrow patents. However, American businesses are being hurt by the significant costs and uncertainty caused by patents of dubious quality. Instead of continuing to waste the resources of our nation's industries on low-quality patents, we need to implement ways to improve patent quality on the front end. Thank you.
Well, thank you very much. And next we have Mr. Lester, Tory Lester, Vice President Patents, Cushnet Company, Fairhaven.
Hello, everyone. Thank you, Chairman Leahy and Ranking Member Tillis, and members of the Intellectual Property Subcommittee for allowing me to discuss the importance of improving the quality of patents. Patent law is extremely important to our economy, and we need to get it right. We want to fuel innovation, not stimulate litigation. Good patents, patents that are directed to new innovations and that stand up to scrutiny, help promote further innovations and promote a company's research spending. Overly broad patents do not teach anything and stifle innovation. For more than 20 years, I've led the patent group at Cushnet Company, the owner and steward of golf's leading brands, Titleist and Footjoy. We have manufactured golf balls in the United States since 1935. We are extremely proud to manufacture in the United States. Doing so allows us to control our manufacturing processes. However, manufacturing in the United States also subjects us to bad patents. We understand the value in possessing good patents and believe in the patent system. We have obtained about 2,700 golf-related patents over the last 20 years. Cushnet has licensed and purchased good patents from individual inventors. When we conduct freedom to operate searches, patents will be discovered and we'll have the opportunity to obtain rights and use the ideas. And Cushnet has successfully asserted good patents when necessary. I would much rather spend money asserting a sound patent than one that is likely to be invalid. Conversely, Cushnet has been sued by patent trolls. Patent assertion entities take resources that could otherwise be better allocated towards research and development, improving manufacturing facilities, and creating jobs. Patent litigation abuse is not just an Acushnet problem. There are numerous entities that send letters to over 1,000 various companies demanding a license fee. However, litigation abuse only addresses half the problem of overly broad patents. Bad patents often stifle innovation without ever being asserted because they create barriers for companies to create products or implement process improvements. Companies like Acushnet often avoid implementing technology altogether in the presence of a weak patent because we know that juries can be completely unpredictable when faced with the claim of invalidity. We recently canceled a multi-million-dollar order for equipment made by another US manufacturer because an invalid patent issued. More importantly, bad patents generally do not teach anything new and thus are antithetical to the system's purpose. It is inevitable that there will be some bad patents that issue. However, because they stifle innovation, we should try to reduce them. As a starting point, I would recommend resources be set aside for additional examiner review. When Acushnet reviews an invention disclosure, several attorneys review it and determine what the invention is. The examining process could be improved by a similar approach. Moreover, approximately 10 years ago, the Patent Office was forced with a significant backlog of applications. Examiners increased the number of cases being examined, and training of new examiners decreased from 6 months to 6 weeks. In other words, there was a focus on an increase in the quantity of cases, but not on an improvement in the quality of cases. More importantly, I believe improvements in the implementation of Section 112 are imperative. Section 112 requires the claims to particularly point out and distinctly claim the subject matter the inventor regards as the invention. Section 112 should make inventors claim their actual invention, like a golf club configuration, and not the base properties resulting from their experimentation, like golf club frequency. Similarly, Section 112 should require claims to use the same language that is in the specification. Finally, steps should be taken to reduce the continuation abuse practice. There are applications with hundreds of claims that date back to the 70s and 80s. And I know of golf club cases that have about 100 priority claims. In closing, valid patents encourage and protect innovation and are critical to our economy. Overly broad patents, in contrast, stifle innovation and spur litigation. Litigation abuse harms companies and our economy. Bad patents also create roadblocks that prevent companies from innovating and making new products and creating jobs. I think with improvements, we can begin course correcting. We need to get it right. Thank you.
No, thank you very much. That was very helpful. And now we have Professor Contreras, who's actually here with us. Go ahead, Professor.
Thank you. Chairman Leahy, Ranking Member Tillis, and distinguished members of the committee, my name is George Contreras, and I am a professor of law at the University of Utah. As Chairman Leahy alluded to in his introduction, on March 9, 2020, 2 days before the World Health Organization declared COVID-19 to be a global pandemic, a patent assertion entity named Labrador Diagnostics Oops, sorry. Should I? I'm sorry. Okay. Technical difficulty, even live, these happen. Patent assertion entity called. Thank you. So on March 9th, 2020, 2 days before the World Health Organization declared COVID-19 to be a global pandemic, a patent assertion entity called Labrador Diagnostics sued a company that was about to release one of the first diagnostic tests for COVID-19. The most surprising thing about this suit was the source of the patents asserted. They were just 2 of more than close to 1,000 patents originally held by Theranos, the defunct blood analysis company exposed by journalist John Carreyrou of the Wall Street Journal. According to these and other reports, Theranos never finished developing the tests that it sold to Walgreens and others for millions of dollars. As a result, Theranos founder Elizabeth Holmes, the lead inventor on both patents, is currently under federal indictment for multiple counts of criminal conspiracy and fraud. The Theranos patent litigation highlights a disturbing reality. More than a few issued patents cover inventions that were never made or at least never worked. So why does this matter? Commenting on a widely derided U.S. patent claiming an anti-gravity-driven spaceship, one senior PTO advisor opined that it doesn't cause any problems because the patents are useless. It seems that the prevailing view, both at the PTO and among some patent attorneys, is that patents on non-existent and impossible inventions are mere curiosities, unfortunate but ultimately harmless. But the recent assertion of the Theranos patents offers stark evidence to the contrary. Here are just a few examples of the very real harms that can flow from these bad patents. First, a bad patent can act as prior art, preventing later inventors from getting a patent they deserve after actually developing the claimed technology. Second, the holder of a bad patent can enforce the patent against others who are more successful at developing the technology. This doesn't just happen in court. In fact, this morning, I read a news story about the settlement of a case in the Northern District of Illinois relating to a, quote, bogus patent used by a pet supplements company to game the Amazon takedown procedure for competitive products. Third, even if a bad patent can eventually be invalidated in court, and not all can, patent litigation is costly, and many defendants may prefer to settle, leaving the bad patent on the books to be used against others. And fourth, the existence of bad patents can itself chill new research and innovation, thus reducing market entry, technology development, and competition. More than half a century ago, the Supreme Court recognized in Lear versus Adkins the threat that invalid patents pose to the market and identified the important public interest in permitting full and free competition in the use of ideas which are in reality a part of the public domain. In short, bad patents allow unscrupulous actors to put fences around not yet invented technologies that should be available to the public. For all of these reasons, we need to try harder to prevent the issuance of bad patents. To that end, I suggest the following reality checks to help the PTO more closely align patent allowances to technical realities and to deter fraudulent behavior before the PTO. First, increase vigilance for inoperable inventions. At the examination stage, the PTO should check inventor names against lists of retracted papers, criminal indictments, securities investigations, disciplinary proceedings, and other forms of behavior that might cast doubt on the assertions made in an application. The PTO could also flag other questionable applications, such as miracle cures, cold fusion, and interstellar spacecraft. Second, demonstrate reduction to practice. If an application is flagged as potentially problematic, the PTO should be able to get a third-party verification that the claimed invention has actually been reduced to practice, or that reduction to practice is both feasible and likely, perhaps resulting in some of the gold plating that Senator Tillis mentioned earlier. Third, involve the public. In many technical areas, competitors, academics, and other members of the public are more likely to appreciate the technical challenges faced by a given invention. Thus, the PTO should revive and expand the limited peer-to-patent program, which enlisted expert volunteers in the examination process from 2007 to 2011. In addition, the PTO's pre-issuance submission procedure should be expanded to permit members of the public to raise enablement concerns without the expense or formality of a full inter partes review. And fourth, enhance penalties for fraud. Other than unenforceability of the patent in question, there is no explicit penalty for fraud, either private or administrative, under the Patent Act. Accordingly, the penalties for seeking to procure a patent through fraud or to enforce such a patent should be expanded to include both criminal sanctions and substantial fines. It is in everyone's interest to eliminate bad patents. I hope that these modest suggestions can help us achieve this important goal, and I thank you for giving me the opportunity to testify today.
Well, thank you all very much. Ms. Asay, you explained your testimony. The Vermont Attorney General's office heard from two nonprofits that were threatened by the entity asserting low-quality scan-to-mail patents. I believe they demand as much as $1,000 per employee to settle. What type of impact would a settlement of $1,000 per employee have on the ability of these nonprofits to support the communities they were serving?
As you well know, Senator, things operate often on a much smaller scale in Vermont, and the impact of facing the financial demand for $10,000 or $20,000 or $25,000 for a small nonprofit working in a community, it could be substantial. And even having to involve counsel to assess the letters that a nonprofit receives and decides how to act is money that could have gone to other services. And instead had to be spent to fend off these kinds of claims.
You know, when I think about all the work that goes into this, you did some research looking into the status of MPHJ's patents to determine whether any of the claims asserted against Vermonters were still valid today. I use Vermont as an example because this could be any state. Did it take significant work to learn the status of the patents?
It did. I spent a fair amount of time going back, and I have a law degree and I have access to Westlaw, which is a paid legal research service. And it took me a fair amount of time to track back through the litigation on multiple different patents and determine the outcome. So it was not an easy task, and I think not something that a lay person, working at a nonprofit or small business could easily have done.
Well, and most small businesses don't have a large legal department that can take time to do this. I wonder if it helped for any claim if you have a claim that was invalidated, either at the PTO or in the court. What if the status of that claim were clear on the face of the patent? Would that help?
Yes, I think that would help. I think transparency is a terrific goal in this area, and it's my recollection that back in 2014, when this issue of patent enforcement was something that state attorneys general were learning about, that there was a bipartisan coalition of state attorneys general that joined in some letters and some suggestions about reforms, and that they in particular focused on the need for transparency, the importance for people to know who they were dealing with, and the status of the patents that they were being faced with.
You could almost say that makes common sense.
Yes, Senator.
And Professor Contreras, you mentioned that Theranos had almost 1,000 patents. I'm so boggled by these numbers, considering what it was for a company. They later sold that to a holding company. I understand that Elizabeth Holmes was indicted for fraud in 2018. But then, isn't it true that PTO continued to issue patents in the name of Theranos and with Elizabeth Holmes as a named inventor into 2022, 2 years after she was indicted for fraud? Is that correct?
Yes, Mr. Chairman, that is correct. One of the two patents that was asserted against BioFire, the medical testing company in Utah that I mentioned, was issued in January of 2020, which was 2 years after the criminal indictment.
Well, an indictment that, everybody knew she hadn't actually invented the diagnostic methods she claimed. Is there any real basis on which she should have gotten those patents?
My opinion is that the patent should not have been issued. That's why I'm here testifying before you, Mr. Chairman. I do believe that the PTO, there are signals that the PTO should be aware of and should respond to when applications come down the pike for inventions that are not actually reduced to practice as they need to be.
When we had some talk about where fees are, I'd ask Mr. Lester, the PTO was funded by user fees, and those fees are set by the PTO. And now the application fees are low, and maintenance fees incurred after a patent issues are comparatively high. Many companies game that system. They apply for a huge number of patents rather than focusing on securing the highest quality ones. Then years later, many of these patents are abandoned before maintenance fees are paid. It seems almost like a Ponzi scheme. And I wonder if increasing upfront application fees might help mitigate that kind of gaming. So my time is really up. And I ask you one question. I'll submit others for the record. Would you be comfortable with the trade-off of paying more upfront for your patent applications and paying less in maintenance fees later?
Well, Senator, from my experience, the recent increases in maintenance fees made us seriously scrutinize every patent in our portfolio. Every quarter, we review all of the patents that have maintenance fees, and we particularly scrutinize the ones that have the third maintenance fees. The increase in cost obviously made us streamline our portfolio to stay in budget. And as a patent attorney, the only cases you regret are the ones you abandon. An increase in examination fees would have a similar effect in that it might deter application filings and thus kind of stifle the objective of applications of teaching new technologies. High maintenance fees allow applications to be filed and teach, but then frees up technologies so that others can still use them. However, I understand that this is much more difficult for the Patent Office to budget. Another thought would be that continuation applications really don't teach anything new. They are literally the same application filed again and again. And that is how a lot of these entities file thousands of applications. With the many problems arising from continuation applications, and the continuation applications accounting for, I believe, about 25% of the pending cases, an increase in continuation filing fees might be a prudent approach.
Thank you. Senator Tillis.
Thank you, Mr. Chairman. Mr. Lester, Mr. Garceran, can you share any experience with responding to assertions based on fraudulent patents in your current positions?
I guess I'll start. This is Julio Garceran. I have had some experience with, I wouldn't say it's fraudulent, just bad patents that they had no business asserting those patents against our products. And we had that on multiple occasions that we had to spend money to respond to them. And in fact, we used certain threats under Section 285, saying that if they came after us and actually sued us, we would seek attorney's fees. We also used the Anti-Abusive Patent Assertion Act that is enacted in some states, such as North Carolina, and threatened them with that also. And we've had success in warding off the more serious and egregious violations, but some of the ones that I think are less so, they won't go away as easily.
Mr. Lester?
Yeah, unfortunately, we've had our share of non-practicing entities asserting patents against us. Innovatio asserted patents against us for using Wi-Fi. They stated that we had 3 manufacturing plants in Massachusetts. They must have Wi-Fi, therefore you infringe. Helfrich asserted patents relating to sending out tweets, and he offered a license for $15 per 1,000 tweets. So if you have 1 million followers and you send out a tweet, that's going to cost you $15,000. But the most egregious is probably Eclipse. Eclipse was an entity that had a number of patents. In fact, they had a number of patents invalid in 2014, and they still received 2 more patents in 2015 after those cases had been invalid. But those types of situations, they got on our website, ordered a golf club, said, well, that golf club, you must keep track of it in your warehouse. So therefore, it's a mobile thing. And then you sent us an email back saying that you would ship it to us. That is standard practice of anyone sending out products to somebody. And we were very, very fortunate in doing our due diligence. We found out that Federal Express had settled with them. We went to Federal Express thinking they would have much better prior art than we would on this type of technology. And they did. But they also had an agreement with Eclipse that they wouldn't file any cases against Federal Express customers. So the next day, Federal Express happily sent Eclipse a letter saying that they were in breach of contract. And the following day, the case was dropped. You know, we were, again, very fortunate that we had the means to be able to go out and look for all of that information. It took months and it took a lot of resources. But again, we were on the very fortunate side of that.
And this is happening every single day. I have a question for Mr. Lester, maybe for you also, but Professor Contreras and Mr. Garceran. We've, over the years, heard a lot of stakeholders being concerned with patents being issued that do not appear to satisfy the enablement or written descriptions found in Section 112. We've think that maybe the interpretation or the application of Section 112 is inconsistent within the USPTO. What's your view, and what should we do if you agree that its application and its interpretation is inconsistent? What suggestions would you have as a matter of statutory changes to correct that, not only for the USPTO but for the court's application of 112? Mr. Contreras, we'll start with you.
Thank you. I'm happy to start, and thank you for the question, Senator. I do agree with you. I think that a lot of these problems do arrive under Section 112 enablement, which has really 2 prongs. There is the adequacy of the written description. Do you actually enable somebody to make the invention? And there's a lot of litigation with respect to that prong. I think the more important prong, and where we see the bigger problem, is did you actually reduce the invention to practice yourself before getting those claims? And this is where I think we see a lot of quote-unquote wishful thinking being issued patents. I do think that the examination process can be made more stringent in order to try to catch those unpracticed, non-enabled inventions before patents are issued by doing things like having triggers within the PTO to alert examiners when there are particularly suspect inventions that are coming down the pike, getting outside expert reviews. I know that the PTO staff is limited and stretched very thin, but we could enlist the aid of outside peer reviewers, as we do in the scientific community with journal articles, to attest to whether or not an invention is reduced to practice or likely to be reduced to practice before it's issued. And then there's the idea of peer-to-patent, which was tried out on a very limited basis from 2007 to 2011, but which enlisted members of the public, experts, university people, competitors, to look at prior art with respect to patents that were in the application process. That could be used to deal with enablement as well as prior art, and I think in a very useful way.
Mr. Garceran, you have anything to add?
Yes, I'd like to add that I do think that the enablement standard is not applied early enough. I think we do have the laws on the books, but usually it takes for litigation for them to be applied, and we really need the examiners to have some incentives put in place, or at least some training or something, but an incentive where they need to be examining using an enablement standard to show proof that the invention the inventor is trying to obtain, they actually have, and they actually possess the invention, and they're teaching society how to use the invention and how to get the invention. And that is not currently pushed very significantly at all in the examination stage.
Thank you all, Mr. Chair. Thank you. I just want to reinforce, I believe that there are a lot of people in the USPTO that do a good job. I do think a part of this is resources. That's why I feel strongly that we should end fee diversion, reinvest in information technology, reinvest in more resources. And Mr. Contreras, you mentioned in the one case dating back from last year that having examiners have access to information sources that they're not using today. I think you were talking about criminal records, et cetera. I think that we should also take a look at better collaboration and use of information for prior art searches, all the way from, let's say, collaborating with the whole of government, the FDA, and other resources that may be helpful to have a more fulsome set of data as they're going through the examination process. Thank you all for being here. Thank you for letting me go over, Mr. Chair.
Thank you, Senator Tillis. You and Senator Coons led this committee so well, and I have the honor of following Senator Coons in that, and I yield to him.
Thank you, Mr. Chairman, Ranking Member, and thank you to the panel for this conversation. I'll follow up on the comments just made, just more broadly recognizing that a decade on, the American Vents Act deserves the reexamination, the discussion it's having today. Patent quality really matters, and making the investments and making the changes in the system that can improve patent quality is an important thing for us to have done. And Mr. Chairman, I'll congratulate you again on the American Vents Act, which I think was critically needed at the time to significantly improve patent quality at a moment when the patent system was improvidently granting a very wide range of patents, and there were a lot of challenges and issues to look at. But I'll also agree, I think, with both the ranking member and the chairman and a number of the witnesses that we need to invest. If we're going to have the best quality patents in the world, we need the best examiners. We need to end fee diversion. We need to make sure that investments that companies are making in the system actually produce improvements. We need to invest in modernizing the technology and in providing ways that we get the best-in-class examiners who are actually not just capable, competent, even masters of the fields in which they're conducting examinations. So I think there's a lot of work to do that we can all agree on to improve patent examination and patent quality. But I do want to make sure that the pursuit of patent quality as such is not used as an excuse to weaken enforcement mechanism protections for all patent owners. So let me just ask of the panel a few questions, if I might. The USPTO's 2020 Performance and Accountability Report concluded that examiners are correctly applying the statutory patentability criteria about 93% of the time. Is this a relevant and effective gauge of the quality of patent examination, and what's your perspective on this analysis? If I might, Mr. Garceran and Professor Contreras, and then the other members of the panel who are not physically with us.
Well, I'll say 93% sounds like a pretty good grade. I don't know what the exact parameters that went into that grade, but I do think, as we've been talking about and while we were having this meeting, there are clearly some issues with patent quality. And again, I agree with some of the testimony here and some of the statements that the use of Section 112, especially enablement and written description type of examining standards, if they are consistently used, that could lead a lot to improving patent quality on the front end.
Thank you, Mr. Contreras. Professor Contreras.
Thank you, Senator. Yeah, so I don't doubt those statistics at all, but I would point out that the rules, the examination rules, don't actually require that the examination look into the actual reduction to practice of patents. To do that would be difficult because, of course, examiners don't have the ability to test apparatus. We don't submit working models anymore to the patent office. So that is very difficult. We also have doctrines like constructive reduction to practice. Simply filing a patent application is good enough to count as reducing the invention to practice. And prophetic examples that appear in lots of patent applications, particularly in the biopharma sector, where they describe experiments that are just hypothetical. But those hypothetical experiments that were never conducted are good enough to demonstrate reduction to practice. I think changing some of those rules might actually help in grounding some of the issuances in inventions that are actually real and reduced to practice.
Mr. Lester, if you might, and then Ms. Asay.
Yeah, very quickly, I'd like to add, for example, in the Eclipse litigation, those claims were directed to sending signals to a bus or a taxi to see when it was going to arrive at your stop, right? The claims were directed to a mobile thing. That is the situation where something was taken completely out of context and then asserted against thousands of people for selling things on the internet. The application of 112 and reducing that to what is actually the invention in the application would go a long way to stopping these overly broad patents.
Ms. Asay?
Thank you. I would just reiterate what other witnesses have said about the importance of strengthening the examination process to improve the quality of issued patents. Thanks.
Ms. Asay, a great deal has changed in patent law and its actual practice and application since you were litigating the issues with MPHJ Technologies and the infringement letters you were describing now more than 5 years ago. Do you have a sense how prevalent the demand letter practice you were describing is today, 5 years later?
I can say that when I was researching and trying to prepare for today, I did see that, and I don't have any personal knowledge of this, but I did see that the Attorney General of Washington State has recently filed a consumer protection action addressing demands by a non-practicing entity. So although I didn't pursue that further, it does look like there has been renewed interest from at least one state attorney general. I think in the time when we were litigating this back in 2013 and 2014, this became an issue of consumer protection that registered for many attorneys general who were hearing from small businesses about the challenges of being a small business in a tech field and having to, trying to develop a product and develop a company and dealing with patent infringement litigation. And so I definitely encourage states attorneys general again, the National Association of Attorneys General, to perhaps again engage on this topic, because I know that they're often contacted when problems arise and really have kind of a boots on the ground understanding of what is going on.
Well, I would agree that I too heard a lot about this as a concern 7 and 8 years ago, and I think there have been significant changes and shifts in law and practice that have largely addressed it. I'll simply close, I know I'm over my time, Mr. Chairman, by saying that ending PTO fee diversion and making sure that we're investing in high-quality patents and in examinations that are properly incentivized, properly structured, is the right way for us to move forward in a way that we can all support. Thank you.
Thank you very much, Senator Blackburn.
Thank you, Mr. Chairman, and thank you to our witnesses that are here in person and joining us virtually. I represent Tennessee, and as you probably are well aware, the auto industry is there. We have a lot of patent holders, and in this, we have many individuals that have single patents. So I think, Ms. Asay, I want to come to you with this. Talk a little bit about the process that an examiner goes through when reviewing a single patent, and is that standardized, or are there noted outstanding issues and differences with the consistency of a patent quality? Because many of our people file and they have a single patent for a single process, especially when it comes to the auto industry. And then my follow-up on that would be, how can the USPTO best streamline the review process so that it is more consistent and so that individuals that do these single patent filings have an idea of consistency through the process?
Thank you, Senator. I'll be quite upfront that I'm not an expert in the patent examination process. When we heard about the concerns that arose in Vermont, we really came at this from a consumer protection standpoint and tried to understand what was happening and why these demands were being made and how businesses could respond to them. And I think, what we kept hearing over and over again was the cost of dealing with the cost of patent litigation, how difficult it is, how expensive it would be, and the challenges that particularly small entities face on that end of it. So certainly, I certainly agree that improving patent quality at the outset is an important step in preventing the kinds of problems that we were seeing on the other side after patents have issued and are being used by non-practicing entities. But I would defer to the other witnesses to speak more to the examination process.
Mr. Garceran?
Yes, thank you. I would say we need to spend more resources into the USPTO because I think streamlining it would be difficult, whether it be for a single inventor or a big company that has multiple patents. I think they're doing their best. I think that they're a little stretched for time. So I think that one of the solutions would be increase resources to the USPTO so they can have better training, better standard training so that everyone's operating kind of in a similar fashion and there's not inconsistency between the examining force. I think that would go a long way.
Okay. Mr. Contreras?
Yes, thank you, Senator. One thing that I know that the PTO does, and I would encourage them to do to an even greater degree, is offer fee discounts for small inventors and small businesses. When we talk about fees and fee diversion, I completely agree with the sentiments of Senator Coons and Senator Tillis that we should give the PTO the resources it needs, but I do think that large companies can bear much of that burden, and we don't need to burden small inventors with this. That being said, I do think that we need to apply the same degree of scrutiny to inventions that are applied for by every applicant. It is the case that in some cases, patent assertion entities scoop up patents from small inventors with the promise of ready cash payment so that they can then be in less complimentary terms, yes. And we've heard about some of the problems that
Right,
creates.
let me ask you this. Then what about the two-tier system like Germany has, where you can get the petty patent or the smaller patent or the gold-plated patent? Talk a little bit about that and that impact.
So that's actually a really interesting idea, and a number of countries have this. Petty patents, utility models, they're called, where anybody can get it. In China, they do this, and in fact, it's become de rigueur for college applications to the top Chinese universities that your child should have a few patents to put on their application to show just what a brilliant person they are. Those have some value, and in a lot of industries, I can see value if it's a relatively straightforward industry, a mechanical device. We've had important patent cases revolve around things like keychains and tennis shoe designs. Absolutely, there's no need for the type of examination you would have for a drug or for a semiconductor device. So I think this is certainly something that we should look into.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Senator Blackburn and Senator Hirono.
Thank you, Mr. Chairman. Mr. Garceran and Mr. Lester, you both spoke about the need for the PTO to better enforce Section 112 in the examination process. Are there changes to the statute, to Section 112, you think are necessary, or is it an issue of priority at the PTO as they do the application examinations?
I would say, in my opinion, it's a matter of prioritizing at the USPTO and making sure that they're doing that. It may be that the USPTO and maybe the judicial system needs some more explicit guidelines because Section 112 is not very long. It's just a few words. But there is a lot of common law out there to explain what that means, and I don't see there being any problem with that common law. It just needs to be used in the examination process early on at the USPTO.
For example, some of the factors that they're supposed to review, whether it's a patentable subject matter, anticipation, obviousness, those are areas that maybe are easier for the examiner to ascertain, and maybe not. But maybe you would suggest that they prioritize the written description or the enablement parts of Section 112.
I think they can obviously do the prior art searching and things of that, and that's essential and needs to be done. But you can look at a claim, and if it's very broad in the way it's being applied, or there's I think it just needs to be prioritized. I don't think it has to be done in every single case, but it needs to be done, especially when you're dealing with a very overly broad patent or something where it's clear that the whole scope of the patent may not be enabled here. I really need to push this issue if I'm an examiner.
So is that the part that relates to the written description that's being overly broad, or
It would be,
more attention should be paid to that aspect of a patent application?
I think, both written description and enablement, which are, they're very related, but I think it would
Yes.
apply to both.
What about you, Mr. Lester? Do you agree?
I completely agree. I believe that the Patent Office has the capability and the foresight to be able to do it. I think it just needs to be part of their process to take a look at the application when it's filed, look at what is trying to be claimed, and then look at the specification and say, is this really supported? And I think it's something that can be done if we have a very good director in the Patent Office. He can set the parameters for it, and this would be an easy thing to implement.
And maybe more resources to the PTO, such as, I think we're all in agreement that we should end the PTO fee diversion. So for both of you, once again, too often efforts to address claims of so-called bad patents weaken patent rights. Innovators who paid their application fees and prosecuted their patents, often over a period of years, now have to survive sometimes multiple challenges before the PTAB before they can try to enforce their patents against infringers. I hear from many small inventors who are abandoning the patent system because getting a patent just isn't worth their time and investment. Both of your companies rely on patents to protect your investments and to prevent competitors from simply copying your respective technology. What have your experiences been with the PTAB?
Well, I would say initially, a lot of the IPRs that were filed, you would get multiple IPRs against your patents, and it was a tactic that's used, and a tactic that can be used very effectively if you're a small inventor who does not have the resources to pay for such serial IPRs or reexaminations. However, more recently, in the last few years, I think the PTAB has been very good about if an IPR has been filed, they won't institute on some follow-on IPRs because they've, I guess, caught wind of this. But I've seen, at least anecdotally, my understanding is that PTAB has put an end somewhat to that practice.
Would you agree, Mr. Lester?
We've had a significant amount of experience in the PTAB with inter-party reexaminations. And I found the PTAB is extremely good at reviewing patents and providing well thought out evaluations of the validity. Right now, of the IPRs that are being filed, I believe only 50% of them are actually initiated, which shows that they're taking a very good look at the patents and the prior art that's being cited to determine if this should be really going forward or not. What I believe is happening is that when an entity files 300 litigations, they will end up with a lot of IPRs filed against them. When you have an entity that is filing one litigation and pursuing their claims against somebody that practices in that field, most likely they're going to end up with one IPR. And if that patent is valid, it's going to survive the IPR. It might not even get initiated. And I think that's the way the system really is intended to work. I think there is an issue with the abuse of the IPR really when there's a lot of litigation going on.
Thank you. Mr. Chairman, with your permission, I'd like to ask just one short question for Ms. Asay. So Vermont passed the first state law against bad faith patent assertion in 2013, And you were with the Attorney General's office, and you testified that you looked at these issues, these kind of litigation from a consumer protection standpoint. And I think that is very appropriate for the Attorney General's office to focus on. But since then, more than 30 states have passed similar laws. What has been the impact of these laws been on stopping clear abuses of the patent system like MPHJ, Ms. Asay?
I could not find any record that the Vermont law has been used yet, although it may have been, and I just didn't find it. I did do some research to try to see how these laws have played out. And it looks like they've been asserted occasionally. I believe one of the other witnesses mentioned that their company may have used the North Carolina statute successfully, so he may have something further to say. But in the research that I did, I didn't find a lot of evidence that the laws were being used that frequently and that the claims were surviving motion practice. But I did, as I said earlier, I do see that the state of Washington has recently filed a new lawsuit that does rely in part on a statute like that out in the state of Washington. So perhaps there will be some further litigation. There have been questions raised about preemption of these statutes in a number of courts.
When we were dealing with the issue of patent trolls and the hundreds, sometimes thousands of demand letters being sent to often small businesses who paid up, it seemed to me that it was really more a consumer protection issue, and that is why the Stronger Patents Act, a bill I've co-sponsored in multiple Congresses, include provisions that would similarly police bad faith patent assertion. Thank you, Mr. Chairman.
Thank you very much. And Senator Tillis, you said you have no further questions. We'll keep the record open for a week for questions from members of the committee. I want to thank everybody who appeared personally and virtually. This is a complex subject, but it's one where I think we have some pretty common concerns, and I appreciate all the advice we got here today. So thank you very much. Also, when you review your testimony, if any of the people testified find that there was something they wanted to add to it, please do so, and we'll include that in the record. Thank you. Oh, Senator Tillis.
Just briefly, two things. Well, I walked over to your staff before we started the hearing to thank them for the positive feedback I'm getting from my staff and working together on this. I consider this a journey. I'm not a patent attorney. I'm a management consultant. I think we have a problem, and it involves people, technology, and infrastructure. So we welcome your feedback. Consider this a dialogue, not just a once-and-done encounter, and working with, I think I speak for the chair, and working with both of our offices on good ideas for legislation as it moves forward. Thank you, Mr. Chair.
Thank you. And over the years, I've learned far more about patent law than I ever did in law school or in practice or from the days when I was a prosecutor. I've been found very helpful some of the things that Ms. Asay has done in Vermont, but I've found it very helpful, the testimony from everybody here. So thank you very much. Maybe we should do a hearing in Durham and one in Montpelier. Thank you. Thank you all. We stand in recess.